All right, so today we're going to be diving into a little bit about not only the Ripple case, but also take a look at what's been happening with the rest of the market, Coinbase, Binance, and really some scenarios that are starting to play out in the markets, both from a regulatory standpoint, a enforcement standpoint, which is obviously through the SEC. And anytime we do that, we always love to get experts on the show. And today we're going to have John Deaton join us, so it's going to be a good one. My name is Paul Barron. Welcome back into Tech Path. Of course, joining me is Mr. John Deaton from Crypto Law. Great to have you back.
Hey, Paul, thank you for having me back. I appreciate it.
Yeah, excellent. All right, John, so a couple of things have happened this week. Obviously, this has been a busy week. Hinman details and emails were released. I have been following this case pretty extensively, not to the level of, I think, you and Hogan and some of the other attorneys out there that are really tracking this one. But one of the things that, at least from what I've been able to glean so far, is that, this didn't really, it kind of surprised me. I thought there would have been a lot more juice in here than what we got. It did show that there was probably some backroom deals going on between Hinman and the Ethereum Foundation, or the Ethereum group at that time. What is your assessment of that, and how does it help, if it does help, Ripple?
Yeah, Hogan and I talked about, Jeremy Hogan and I and Marc Fagel, and former SEC attorney, we're talking about this recently. And, when you have something built up for 7 court orders, 2.5 years, there's such an anticipation. Everyone's expecting a smoking gun or some bombshell. And no, everything was just confirmed about that. There were conflicts of interest, backroom dealings, things of that nature. You had SEC personnel saying maybe you shouldn't give ETH, say that comment about ETH.
Right.
You had SEC personnel saying this speech is going to cause greater confusion in an already confused market. So you had all this going back and forth. It's relevant to the fair notice issue in the Ripple case, but not the case itself. So, for example, probably the most disappointing thing for XRP holders, and because we're on watch for the verdict, I'm prepared with my shirt here, right? Because that decision could come down any day. And for XRP holders, I think they were hoping that there would be a discussion about, well, if you're giving ETH a pass, why not XRP?
Exactly.
XRP is just decentralized. There was going to be give and take about that. And there was none of that. And so that was probably where I think people like yourself and others were thinking, well, that's not there. So it's not going to affect the judge's decision on whether Ripple sold XRP in a manner that violated the securities law. But if she finds Ripple did violate the securities law, and she allows a jury to hear this fair notice issue, that there was so much confusion in the market, Ripple wouldn't have fair notice to know that it's not a security, then those emails become a big deal because the jury gets to hear all of that confusion, back and forth, backroom dealings, conflicts of interest. Arguably Hinman lied because when he was deposed, the emails were not out and he didn't think they would be out. And the lawyer at the SEC instructed him not to answer questions based on privilege that the judge overruled. So he's asked a question of, did you talk to anyone else other than the SEC about the substance of your speech? And he said no. But we know in an email on June 4th, he said, hey, I'm speaking to Vitalik next week to get a fuller understanding of the Ethereum network. So that implies that he did speak to people at ETH about ETH to confirm, that it's sufficiently decentralized and all of that. And so that's where we stand.
Okay, so with that being the case, from what I've been able to glean from this, and again, this is tons and tons of research around kind of the position now with what we know from the Hinman emails, this looks like there was some, shenanigans going on between Hinman and that. So that's understood. Okay, so we get that point. And that definitely could go in the advantage of Ripple's case, obviously, because of the confusion, market confusion. You're already saying this, even though the SEC officially was trying to get Hinman not to say that. So their position would be, hey, listen, we were trying to get Hinman not to do that. and he went ahead and ignored all the, the recommendations coming in from the office. With that being the case, likelihood, it feels like at this time, this is probably going to go to trial. And I didn't think that this would go to trial. I felt like this would most likely get settled or at some case get some sort of ruling that would at least put Ripple in a better position. What are your thoughts now that we've seen this of the Ripple case actually going to trial?
Yeah, I think the chances of a trial increased. Before we learned, and just remember, Paul, for your audience, it wasn't just the Hinman emails that were unsealed, but it was the underlying evidence, that summary judgment evidence that both sides presented. And so before this all was unsealed, I always said, and you can go back and watch my crypto law videos, that people are underestimating the chances of a jury trial. And I think that for your audience to know, a jury gets involved when a judge says that there are disputed facts that need to be determined. A judge decides the law. Now, when the facts are not in dispute, or there's enough facts not in dispute that she can apply the law and grant summary judgment, she will. Mm-hmm. But if she says, for example, there are a genuine issue of fact of whether or not XRP holders were relying on the efforts of Ripple, or that XRP was acquired for non-investment reasons, or common enterprise, or any of those types of issues, then yes, it would go to a jury. Yeah. Now, if she allows the fair notice defense, then it does go to a jury, because Ripple did not move for summary judgment on fair notice. They stated to her, that's a fact, a question for the jury. So, the best, in many ways, a great result for Ripple would be, the obvious best result is they win outright, right? Yeah. And most people don't think that's going to happen. And I don't think the SEC is going to win outright. And so if the judge says, Ripple in 2014 or 15 or 16, when you did these things, you offered XRP as an unregistered security. And she finds that, but I'm going to allow you to argue that you didn't have adequate notice because of market confusion. Then we have a jury trial for sure. And so I think the jury trial chances have increased at least 50% from where I was before. So I think, but here's the thing, the SEC, they're not good at playing defense, and they're not going to want a trial, and they're not going to want this in front of a jury. So if that result happens, then you would think there would be a settlement.
Yeah.
Right. Because it's okay. Let's just strike a deal and move on.
Yeah, which kind of it does fly in the face a little bit of what Garlinghouse has been positioning here for quite some time, because he's been very confident about what this was going to do. It didn't necessarily do that. I won't say that it was a nothing burger, because it did escalate the situation with Hinman and maybe some wrongdoings, but not necessarily in the actual rule of law, which is, was I in the right or am I in the wrong? Kind of scenario.
Yeah, let me comment, because I know a lot of people feel the way that you probably feel, Paul, which is, Brad, Mr. Garlinghouse. All right, I don't know if I was shocked, right? Because that's he said we'd be shocked, but you got to take it from his perspective, Paul. He was sued individually for an allegation that he was so reckless in not knowing XRP was a security in 2015, when in 2018, the SEC couldn't make up their mind. Hinman's ignoring everyone, intentionally prosecuting Ripple, that it shocks him. You know what I mean? So we got to put it all in our own perspective.
Yeah. Okay. Well, I'll comment on that in a second. I want to jump over to a clip. This is by Hester Peirce basically on the Hinman speech. Let's go to that clip if we can.
So there has been a tradition of staff being able to provide, for example, no action relief, or staff being able to go to a conference and make a statement and talk about how they're thinking about a rule. They're doing it in their capacity as, on the staff, but they're explaining how they're thinking about things. If we really want to shut all that down, people will never be able to get answers from their regulator. And those are answers that people really need to proceed forward. The fact that someone on the staff has said something doesn't mean that I or the rest of the commission agree with that. You really wouldn't want to have a situation where the only time the agency spoke was when it proposed or adopted a rule or brought an enforcement action.
So she's kind of defending what happened there, is that, these kind of things happen. There's disagreements between commissioners and disagreements on maybe positions, which is kind of what makes up the agency's accumulus of how they go to whether or not they file an action. So I think that would be reasonable. And I guess that's my question, is in front of a jury trial, would that be reasonable for a jury trial to say, okay, these are normal things. They weren't really doing anything wrong. But at the same time, Ripple couldn't know that either, because there was confusion, because they're saying one thing and then come back later and do something else. So what are your thoughts on Hester Peirce's comments there?
Yeah, I mean, I understand what Hester is saying, but she's got to look at it from the total picture. No one's saying that you should discourage anyone, the directors or commissioners, from going out. But they put this speech on the website, and Hester Peirce, Robert Jackson, Jay Clayton, these were all fellow commissioners, pointed to that speech as guidance. The problem was, when we get into the trial and the litigation, the SEC took the position that it wasn't market guidance, and that it wasn't meant to be market guidance because it was his personal opinion. What I would say to Hester is, say, that's fine. What you said is fine, but don't pretend that it's not accepted from the market as market guidance. And did you know that the emails showed, the Hinman deposition that I read, it showed that there were people calling it the Hinman test in the market, right? Mm-hmm. It was the Hinman sufficiently decentralized test, no longer the Howey test. And so that's how powerful that speech was given to the market. And so I don't have a bone to pick with Hester. I have it with the enforcement lawyers who are trying to pretend, it wasn't market guidance. It's nothing to do with the SEC. That's silly.
And we're starting to see this come out now in other aspects. You've got, obviously, Gary Gensler on record now, in many cases on video, stating similar facts. At the time, he was not necessarily with the SEC, but he's in a position of knowledge. He's in a position of understanding what's going on in the market. And then he takes an SEC position. And in many places, people could look at that and say, hey, Gensler's now the SEC chair. Oh my gosh, we're going to see an explosion over here because he is pro-blockchain. And in fact, he is the opposite. So many people would look at that and say kind of the same thing.
Yeah, and if you ever get to interview Hester, you could ask her. The problem is, in the Coinbase writ of mandamus that they're seeking, the SEC literally took the position that Gary Gensler's statements are irrelevant.
Yeah,
that's the silliness of it all.
Yeah,
right?
Exactly. That I would agree with.
Right.
Yeah, I would agree with that. Not that they're irrelevant, but the position that, no, this is a person of dramatic influence on the crypto community. Any kind of investor who's out there researching, the same thing goes for stocks, bonds, doesn't matter what it is. You're looking at the experts in the community for your guidance. It doesn't mean they're giving you financial advice, but it definitely has influence, just like the Hinman speech had influence on many people who are starting companies, as well as what was going on with Ripple. So I would agree with that. Last point on this, and then I want to move on to Coinbase, is this headline right here. And I want to get I know you and Marc have talked on this, but Ripple, this is the SEC case we resolved within days. This is the SEC former attorney, Marc Fagel, coming in. I know he was on a show with you. And one of the things he states right here, avoiding speculation, but basically his opinion that a ruling could be expected within days. And he stated that in the delay case, it was likely due to its complexity and the indication of ulterior motives. And then his idea of maybe the SEC winning this thing outright. What is your thoughts on where, I know you and Marc differ, but have, good conversations. What are your thoughts on how his position lines up here?
Well, one thing that surprised me is he said that the SEC should win. That didn't surprise me coming from him. He's a former SEC lawyer,
Former
even though
SEC, sure.
he goes against him as well. I want to share that. But he ultimately said that he thought that the SEC would probably lose with this judge. That surprised me. As far as coming out any day now, that's what I was saying. I'm wearing this shirt because I knew I was coming on your show, and the ruling could come out while we're talking. And so,
and just to be clear on the ruling, for our audience, just to be clear on the ruling, what we're talking about coming out is possibly a summary judgment, correct?
Right. Judge Torres's decision on, does the SEC get summary judgment, or Ripple get summary judgment, or does she grant partial summary judgment? Right. Does it go to a jury trial? That's really the decision that we're talking about, that could be coming out any day now. But I agree with Marc Fagel when he talks about the complexity of the case. Paul, I know there's a lot of people frustrated at how long it's taking, but look at how big this case and its ruling becomes as each day progresses.
For sure.
Imagine
even more so now.
Absolutely. If the SEC wins outright, Gary Gensler will make this the biggest thing that's ever happened at the SEC. He'll say it validates his regulation by enforcement, all the crypto tokens or securities. It'll be a big, big deal. If Ripple wins and the judge sides for XRP is not a security, it's a commodity, et cetera, currency, then that's going to cause a lot of the industry to bolden, right? And become more, okay, we can beat the SEC, we can defeat them. And it'll cause the political momentum to lose a lot of steam. And so I don't blame the judge. She knows how big of a decision this is.
Yeah, pretty huge. Speaking of that, we have two major exchanges that are now in litigation with the SEC, with both Binance and Coinbase. Our headline right here, BinanceUS cutting staff after SEC suit. This is going to be a very costly litigation process for both these companies. Binance saying they're really going after it. Only 10% of the employees were laid off, but most likely BinanceUS. I look at this and I'm worried that their business is now damaged so deeply, much like what it was for XRP holders when the lawsuit began, for XR or for Ripple. What is your thought on both Binance and Coinbase? Do you feel like they survived during these lawsuits? Because this is a little different. Ripple is different because it's a token versus an exchange that's doing business based on this market. What are your thoughts on that?
Right. I'm glad that you pointed that out for your audience, because if Ripple loses the case, they just appeal it and it's business as usual the next couple years.
Sure.
And they don't even have to stop selling XRP because the SEC didn't seek an injunction against them. It would just be business as usual. And even if the judge determined a security, they could still survive, right? They could survive because they only offer it to accredited investors, et cetera, et cetera. Whereas the nature of the Coinbase and Binance cases, the SEC said that Coinbase is running an illegal business. So it's not just about the token, it's about the actual business model that the SEC approved 2 years ago they're now saying is an illegal business. And they're asking to permanently shut down Coinbase as a business. That's very different. Yeah. So it is the absolute existence of Coinbase and Binance as they are.
Yeah, it's do or die for them, I think, in both BinanceUS and Coinbase's case. You look at Coinbase, their position is also starting to get interesting because now it's possible they could be losing some retail traders over to Robinhood. And this is something that we've talked about here on our show. Robinhood goes out, voluntarily delist, knowing that these were targeted as securities. A lot of these blue chip tokens, Solana, Matic, etc. Robinhood also has some very interesting aspects around crypto. One of the biggest things I don't like about Robinhood, at least from a crypto trader standpoint, is the ability to transfer more than $5,000 a day in crypto out of Robinhood. To my knowledge, that hasn't changed. So this would be interesting if Coinbase does start to lose position to Robinhood, who is a broker-dealer and does have crypto on it. What makes them so different than what Coinbase is doing right now?
I mean, here's the thing. Coinbase did the same blueprint that Robinhood did. When the SEC said that XRP was a security, Coinbase delisted it and was trying to play nice with the regulators. And I think Robinhood is trying to do the same. Let's not forget too, Paul, Coinbase has a dormant broker-dealer license that they tried to activate, and the SEC wouldn't let them.
Wouldn't let them.
I mean, and so you're right. It appears this is the problem that we have in our country, is where you have, unelected
winners and losers.
Bureaucrats. You and I are sitting here struggling. Well, why is Robinhood this way? Why is ETH? Why is XRP? All of these things. In the meantime, I think what I said to Charles Payne on Fox Business is coming true. And maybe you're going to talk about it, which is crush this market and let the incumbent players come in and get bigger shares. I really think we're witnessing that in real time.
Yeah, we're going to talk about that toward the end of the show. What's your opinion on that? Because that's a big deal. Coinbase is trying to up the ante, though. Here they are offering USDC rewards, jumping up to 4%, even though money market right now is at 5%. So they're not necessarily going to see a lot of movement in that space. And it is USDC, which we saw Jeremy Allaire, among many other experts around crypto in general, throughout the litany of congressional hearings over the last week, 10 days. So there's been a lot moving in this direction. And then you've got other exchanges now. So you've got crypto.com potentially now at risk. That will most likely happen from the SEC, though it has not happened yet right now. And remember, you had Solana, Cardano, Sandbox, Matic, Chili's BNB, Algorand, etc. These were just some of the tokens that have now been listed or deemed as securities by the SEC and said, okay, so you've somewhat decimated all of those businesses and projects, I'll call them projects rather than businesses, in the United States, while all of the other things that are happening globally seem to be moving along without the United States really kind of being part of that. So I'll get off my rant about that. I want to jump over to the topic.
So if I may say,
yeah, go ahead.
If I may interrupt you, Paul, to say that I believe when you add up all the tokens, the SEC is claiming in excess of 60 to 67 tokens are
exactly.
under security. So I just want your viewers to know what you're saying is I understand why you're ranting, because that's the whole game. That's the whole game, brother.
It's a big part of it, at least for the United States. I think this is the challenge that I have, is that Americans are the ones that are basically losing out here. And whether you look at digital asset as a freedom right and the ability to buy something and trade it on on open markets, which is already being done in so many different collectible communities. You can name all sorts of luxury items, art, watches. I mean, you could go on and on about these kinds of communities already exist out there to this level. It's just the difference is this deals with money, and there is an incumbent system that doesn't like that. And we all know who they are. Major financial, banks, Wall Street, all playing into that. Speaking of that, and playing this out, we put this tweet out yesterday. This was our SEC plant tweet. It did pretty well. But the point is that this is a company called Prometheum. And I know this just in general, I wanted your opinion on this. I know you haven't analyzed this deeply, but there was a couple of things. This is the company that was one of the companies that we believe was positioned there by the SEC, or at least asked, you should go and talk about it, why we approved you as a broker-dealer, the only real securities broker-dealer out there for digital assets. And then this has surfaced out there along with many other things. These guys have not been doing a very good job of this. I'm going to play this for you, and you can listen into this and tell me what you think.
Prometheum's team are experts at the intersection between securities regulation, the brokerage industry, and the distributed ledger technology. And basically, beyond our partnership here, as I mentioned before, Shanghai Wangzhang Blockchain is our co-founder. They're not a partner, they're our co-founder. We work hand in hand with them. And leveraging their excellent resource and expertise, we really feel that we can achieve our business plan in an efficient and intelligent manner.
All right, so I'm going to stop it right there. They were the first crypto company to be approved by the SEC. FINRA, special purpose broker-dealer license. They went in front of Congress, including the guy that was just there, Mr. Kaplan, went in front of Congress this week, and when he was point blank asked if China had any control of his business, he simply answered they have 25% and have no control. And obviously in that statement right there, they are a co-founder, in fact, of Prometheus, per his words, which makes me look at this and go, all right, now you've got the Chinese involved in this company. You've got the SEC approving this company. I mean, how would you look at this as an attorney, John? I mean, you're looking at these kind of things just on the surface.
Well, the first thing I would say is that there is very disturbing facts about the Chinese influence. When I say Chinese, I'm not talking about the people. I'm talking about the CCP and the government infiltrating and obtaining regulatory capture with our SEC. There are serious concerns, and so that would concern me greatly. To bring it to your audience full circle, a lot of people believe Ripple was targeted because Alibaba's Alipay was trying to buy MoneyGram, and then that deal got squashed by like national security interest, and then Ripple bought 9% of MoneyGram. And a lot of people believe that made them a target. And so it is just very concerning. Also, to the CEO of that company, it's like looking at someone posted, I forget who it was. I'd give them credit if I could, but they posted a vending machine with nothing in it. And that's basically Prometheum. 75% of the market is what two tokens, Paul? Bitcoin and ETH. And you can't trade it on the platform.
Yeah, that was on the only approved digital asset broker dealer out there, which is ironic. We're going to play another clip from Hester Peirce. Let me jump to that real quick because she's talking about Prometheum specifically.
Okay.
One of them in particular, Prometheum, received a special purpose broker-dealer license. And I wondered what you thought of this as a path for existing crypto exchanges such as Coinbase, Kraken, Gemini, et cetera.
I think people really need to look at the conditions in that relief and see how narrow they are and ask whether is that really the solution, the regulatory solution that we're looking for. My response would be, I don't think that's the regulatory solution. We need to really sit down and come up with a serious framework.
Prometheum's CEO, Aaron Kaplan, seemed to imply that Ether, for example, is a digital asset security and so could be listed on the Prometheum site. Do you agree with that?
Laura, I'm not going to speak to that. And I think we have to see how this develops. The approval just came through. I haven't had a chance to talk to the particular company post-approval, so I don't know what their plans are. I think that the issue, though, is that we have to stop thinking about just putting our existing regulatory framework, insisting that our existing regulatory framework doesn't need any adjustments at all, when Congress told us, we're giving you exemptive authority, we're giving you the ability to make adjustments.
As an example, there's 773,000 validators on Ethereum alone. And so forcing them to become an organization forces them to become centralized. So what's your response to this notion that this change in rulemaking could effectively ban public blockchains in the US or force blockchains themselves to become more centralized?
We want to do away with intermediaries so that people can interact directly with one another, or more accurately, interact with code. So your response to that is to say, find an intermediary because we want to be able to regulate it, or your response is shut down, or your response is get out of the United States. I don't understand how that benefits the American people.
However, and whenever he leaves, how committed is the staff to applying or enforcing the stance that everything in crypto besides Bitcoin is a security?
The way the commission goes will depend on who's running the commission.
Whew. Who's running the commission? So this is opinion. Again, this clearly with Prometheum, it feels like this is a shell company or a prop up. For what reason they approved this? Even Hester was saying that not likely the way forward. Why would they even approve something like this? What would be the purpose?
Well, it's because it's politics. It is 100% politics. In addition to the credibility issue that you raised with showing that video and the Chinese connection, the CEO of Prometheum in April of 2021 was singing a different tune. He was talking about how we needed new rules, new legislation, everything that Hester was saying he agreed with, but something changed. And what changed is that, and I hate to talk about it, but the existing administration has went anti-crypto. Elizabeth Warren on her platform, Gary Gensler, they chose to do that. And so the Democrats brought Prometheum on as their star witness. And so I think we just need to take that with a grain of salt. And it's because she's right. Just think about it, Paul. We're talking about the Securities Act, the Ripple complaint, the Coinbase complaint, the Binance complaint says the following, that they violated Section 5 of the Securities Act of 1934. That's a direct quote. 1934.
Yeah, 1934. Yeah, exactly. I mean, we're going on 100 years here. So let's talk about one last thing here, and I think this kind of leans us out, but this is markets and cryptos regulation that's going on in Europe, which is MiCA. Everybody has kind of heard us talk about this. I'll zoom in on this because this is the timeline of what's happening right now. June of 2023, we get publication in their OJU, and then they get these consultation packages starting in July and October, mainly meaning companies can start to come in and they're going to start packaging deals on these authorized, whether it's a security, whether it's a commodity, whatever it might end up being, and for regulatory approval, which is going to go into the European markets. This seems to be on a hyper track just in 2023, and it looks to be full into application by later in 2024. So much farther in advance. Do you think the United States can catch up on this, or do you think we are going to see years of potential litigation playing out and political pawns being played out as well?
I'm going to hate to give you the answer that I'm going to give you, but because we're in an election year coming up, politics are going to be divided, and we're not looking at anything from Congress probably into the late 2025, assuming a new president or a new Congress, Senate, whatever, or more bipartisanship. You're looking at late 2025, 2026. In the meantime, you've got these regulators out there at the UK, and Hong Kong, and UAE, and Dubai. What are they saying? They see what's happening in the United States, and they're racing to get that capital. I think I just read, Paul, that A16Z is even opening or moving something overseas.
Yeah, going to London.
You have Coinbase, allocating more resources overseas. So it's bad news. And I think that we're probably can we catch up eventually? Yes, but I think there's going to be a long, they're going to have a long lead. These other jurisdictions are unfortunately going to get a long lead, unless we get some great news from the Ripple case and that builds more political momentum. But
yeah, I can't imagine being on watch right now as a House rep or a congressman under these circumstances, because this essentially will go down in history as the people that let this get by. Basically let the United States fall behind. If we had done this in the era of the internet, I mean, there's no telling. It's possible to. Yeah, you would. The United States might not be a global power, literally. So these are the kind of things that could be taking place. Last tweet here is Patrick McHenry. He's one of the architects of trying to defend this, but it feels like even he could get kind of tugged as a scapegoat here of not pressuring hard. And this, of course, was the situation where the potential here for BlackRock getting an ETF, for a spot ETF, could come into play. And of course, McHenry says, all right, we're watching this very, very closely, and goes back to our statement of picking winners and losers, where the SEC has these kind of controls. Other aspect of this, some people say, all right, this could play both ways. BlackRock could get approved, and maybe even Grayscale, could get approved. And in together, they would get propped up into multiple ETFs because it can't surely just be BlackRock. That would obviously be too out in your face that they are clearly picking winners and losers. What are your thoughts on that?
My thoughts are, I don't think that they even care to be that blatant about it, Paul.
They don't care. They're just going to do it.
They just don't care. You see that we're getting to where we're only going to have 5 banks in the United States if things keep going the way they're going, and you have Gary Gensler saying that Bitcoin, and he includes Bitcoin, are used for terrorism and drugs and all of this. Yet you got NASDAQ says they're going to custody Bitcoin. Yep. You've got BlackRock coming in saying they want a Bitcoin ETF. And so I think there's a part of me that's always believed that Gary Gensler and the others have finally accepted that crypto's here to stay. Now, that doesn't mean 20,000 tokens. That means real projects with real utility are here to stay.
Yep.
Are here to stay, but we're going to crush them so that the BlackRocks and the JP Morgans and the Goldman Sachs can come in and get a larger piece of the pie. I wouldn't be surprised that they continue to suppress it, Paul, and then all of a sudden Gary Gensler's phone rings and Larry Fink or someone says, hey, we just bought 25% of Coinbase. Let's work this out. And then all of a sudden, maybe they'll become more amenable.
Well, that's exactly what most likely will be. I mean, this is something we see in Wall Street all the time. It's a normal process of IPOs and among many publicly traded companies kind of going in this direction. John Deaton, always fun getting into it with you for sure.
Always
so thanks again for stopping in. We appreciate it.
Thanks, Paul. See you next time.
All right. So you guys are tuned in over on the, maybe on the podcast side of things. Jump over here to the YouTube channel. It's the best place to catch all of our charts and our analysis. And the other thing you can do, of course, here is click the link down below. It is the Diamond Circle. It's the one place you can get additional podcasts and more content from me. We do it all through the Diamond Circle and then our member groups, which is pretty simple if you're in the CPI or maybe in a mastermind group. But it all starts with the Diamond Circle. Of course, also, if you want to hit me up, you can do it out there on Twitter @Paul Barron. It's that simple. We'll catch you next time right here on TechPath.